Hi, my name is Tamara Slater. I recently graduated from Washington University School of Law, and I'm currently a fellow at the Whitney R. Harris World Law Institute at WashU. First, I'd like to thank the conference organizers for hosting this fantastic, nearly carbon-neutral conference. I often find myself sitting on an airplane reading about climate change, totally aware of the hypocrisy, but unsure of how to fully engage in the world without reinforcing some of the most harmful structures that we've created. This conference is a fantastic example of how we can start to rethink the tools that we still need for the world as it is today. Also, this is a fairly short talk. I do intend to publish a paper based on the research and argument that I will present here, and so I'm really looking forward to constructive feedback, comments, and suggestions over the coming weeks. Climate change has impacted many of the choices that I've made in both my personal and professional life. For many people, however, they haven't had the luxury to plan for climate change. There are folks all over the world who have already been impacted deeply by the droughts, extreme weather events, and armed conflict that have almost certainly resulted from climate change. Even more people have been harmed by other environmental damage that is related and also likely causes climate change, such as harmful energy extractive methods that pollute both water and air while releasing greenhouse gases. There's a term for this, sacrifice zones. It describes communities and land that have been sacrificed in the name of dirty energy development and growth. As Naomi Klein explains, they are, quote, places where residents lacked political power, usually having to do with some combination of race, language, and class. And the people who lived in these condemned places knew that they had been written off, end quote. Sacrifice zones, for example, include communities living next to coal-fired power plants. They include native communities living on land with tar sands oil, and many residents of small island nations. Even more broadly, there are many marginalized and disempowered communities that are hit by extreme weather events, sometimes caused by climate change and sometimes just hinting at foreseeing the disasters to come. Oftentimes, these communities are also unable to handle the humanitarian crises that result, either due to a lack of financial resources or political will. Some examples of these include Red Hook, Brooklyn, New York, where some communities were left without electricity, medication, and other services for weeks following Hurricane Sandy in 2012. The following year, Typhoon Haiyan hit the Philippines, killing thousands of people, and prompted a passionate plea by that nation's representative to the United Nations climate change negotiations that year. And finally, the heat waves in India that have been getting hotter and hotter every year, also killing thousands of people. In this talk, I seek to explore why, as a global community, we have been unable to successfully heed the warnings of decades of scientists about the harmful consequences of climate change. I believe it is instructive to explore this failure through the lens of critical race theory, a critical legal jurisprudential model that seeks to link law with race and power. By using that framework, I hope to show that people who are passionate about climate change need to recognize and understand the hierarchies and biases within our system in order to protect the progress that we've made so far and to make sure that we continue at an even more rapid pace. I argue that for there to be an effective response to climate change, we must first recognize that much of the current inaction is deemed acceptable because of who is being harmed. In a 1985 Harvard Law Review article, Derek Bell, the first African-American professor at Harvard Law School and one of the founders of critical race theory, introduced the world to this new framework and style of writing that seeks to deconstruct and explain racial inequity within the law. That style relied heavily and profoundly on allegory. The following is an excerpt from the Chronicle of the Amber Cloud, one of the stories he presented in that 1985 article. The amber cloud descended upon the land without warning. By morning it was gone. But in its wake, it left a social transformation. The most fortunate young people in the land, white adolescents with wealthy parents, were stricken with a debilitating affliction, unknown to medical science, but whose symptoms were all too familiar to parents whose children are both poor and black. The media called it ghetto disease, a term that made up in accuracy what it lacked in elegance. After a year of strenuous effort, the president announced the development of a very expensive treatment. Civil rights leaders hailed the discovery and urged that the treatment be made available to non-white youths whose identical behavioral symptoms were caused by poverty, disadvantage, and racial prejudice. Legislative action was taken to authorize the billions needed to effectuate the cure. It included a targeting provision that specifically limited access to the treatment to victims of the Amber Cloud. Over the furious objections of minority group legislators, the Amber Cloud Cure Bill was quickly enacted. The treatment supply was exhausted. The nation and its most privileged youth returned to normalcy. Through this story, Bell is demonstrating the interest convergence principle, which states that challenges being faced by minority groups will only be adequately addressed when their interests converge with more powerful communities, most often white and wealthy. As he illustrates in the Chronicle, however, finding such a convergence is not easy. In fact, he was unable to come up with an allegory that truly created such interest convergence. Bell speculated that, quote, if an actual crisis threatened both blacks and whites alike more clearly than did the Amber Cloud, and if immediate and collective action were required, then perhaps the country might rise above its usual priorities and address common needs without racial bias, end quote. I believe that there is no crisis that will ultimately threaten people across race and power more clearly than climate change. The harms currently are disproportionate, but that will not be the case forever or even, I believe, for very long. The sacrifice zones are growing, and therefore fewer people are willing or able to ignore the harmful consequences of extractive industries. The next decade will see more extreme weather events all over the world, more oceanfront property being threatened by sea level rise, and more Hurricane Sandys. I already mentioned Hurricane Sandy within the context of Red Hook, Brooklyn, but we have to remember that it also hit Wall Street, and it destroyed properties in Atlantic City, causing some serious economic reverberations. Many folks talk about climate change in terms of future harm, but we know those harms are already here. I argue that because those harms are currently disproportionately impact poor people and people of color, we lack the meaningful tools necessary to force real action on climate change. If we can recognize the racism and bias within the system and highlight how these interests converge, we can simultaneously dismantle those harmful structures and encourage and force real meaningful action on climate change. Legal scholars frequently highlight the lack of effective legal tools for combating climate change-related harms as well as environmental inequities more generally. I'm going to go through some of the major legal avenues that I believe should be available to folks seeking such enforcement or such compensation, but often are not available. On the international front, you have to start with the UN Framework Convention on Climate Change, or UNFCCC, and the most recent agreement from December of 2015 in Paris. The Paris Agreement does have the potential to encourage countries to take substantial and meaningful action on climate change. There are provisions that are, quote, legally binding, but what that means is still not entirely clear. What is clear, however, is that Article 8 on loss and damage has explicitly not created an obligation on the part of wealthier nations to compensate poorer nations that have emitted very limited quantities of greenhouse gas for loss and damage that results from climate change. While there are important practical and political reasons this was the case and that it was not a legally enforcing provision, for many folks, this represents a major equity gap within the agreement. Laws such as the treaties coming under the UNFCCC and treaties in other contexts covering different subject areas are often, of course, enforced through litigation. The Sabin Center for Climate Change Law at Columbia University has made available on its website hundreds and hundreds of pages of documents with climate change-related litigation both inside and outside of the United States. Despite these hundreds or thousands of lawsuits that have related to climate change, there have been very few where the outcome of the case or the decision of the case was really in their favor. That being said, one can certainly argue that a lot of these cases are important in terms of shifting the narrative, highlighting the faces of the consequences of climate change, catalyzing community organizing, and otherwise, and potentially creating new legal jurisprudence that will allow for future litigation to be more effective. A number of attempts to bring climate change cases in international forums are particularly relevant, and I just want to name them here. The first being the Inuits petition in front of the Inter-American Commission on Human Rights in 2005, which was ultimately dismissed, as well as two cases brought in front of the International Court of Justice, one by the Maldives and one more recently by Palau. These judges do often recognize the scale and complexity of harms related to climate change claims. However, they have frequently been unable to find law on which to have rulings that require compensation or prohibition of certain actions. In addition to the UNFCCC and climate change specific laws, there are thousands of other treaties and state practices that establish international humanitarian law and norms, many of which are directly implicated by climate change, such as life, health, water, and food. Most human rights instruments, however, were drafted prior to the modern environmental movement, and so they don't explicitly protect the right to a safe, clean, and healthy and sustainable environment. Adding this sort of human rights focused language to our climate change laws and treaties going forward, as well as reading into the current treaties that relate to human rights, the need for a healthy and sustainable environment, are going to be essential steps if we want to try to create legal tools, legal mechanisms for the most vulnerable to protect their rights on both domestic and international forums. The Paris Agreement does have language about equity and human rights within the treaty, within the proposed agreement, primarily in the preamble, which is an important win and is a result of a lot of advocacy work. However, as I already mentioned, whether or to what extent that is going to be legally binding is very much up for discussion and debate. I will note that there are some encouraging signs. For example, there is a lawsuit currently in U.S. federal courts that was brought by a group of young people, I believe ages 9 to 19, arguing that they brought a lawsuit against the U.S. government, and they're arguing that failure to take meaningful action on climate change actually violates their constitutional rights to life, liberty, and property. A U.S. federal judge recently held that that was a justiciable argument, and so we'll see that case moving through the federal court system over the coming months, which is really encouraging. This type of lawsuit that uses protections based in a broader understanding and system of rights might be an incredibly important and powerful path forward. In conclusion, I'll just reiterate that in order to really understand the failures within our international and domestic legal systems and the inability to create meaningful tools for folks to use to get compensation and protect their communities relating to climate change, we have to recognize that the populations that are being harmed today are repeatedly inadequately protected. There's no lack of scholarship on what needs to happen on both the legal and scientific fronts. However, we have been unsuccessful at instilling a true sense of urgency and perhaps unsuccessful at recognizing that this is truly global. I believe that there is interest convergence between the populations that have political power and those that don't. In recognizing that convergence, we can undermine the forces that, one, allow for such a distinction between communities to exist to begin with, and two, really ensure that we can take meaningful action on climate change going forward. We can also create more powerful movement alliances, which ultimately is going to better protect marginalized people, better protect the climate, and better protect human life. Thank you for listening to my talk today. I'm really looking forward to discussion over the coming weeks.